Hi, Kevin Keener with TrademarkComplete. This video is about intent-to-use applications versus an in-use in commerce application. So whenever you file a trademark, there are two ways to file an application. The first is known as essentially a standard application. It's an in-use in commerce application. What this means is that you are actually using the trademark in commerce at the time of filing. In commerce means that you have the mark on the goods or services that you're selling at that time, and you have had paying customers by that time. So, for instance, let's say you start a website on January 1st. You are using the mark on the name of the website. You launch, nobody comes and buys your services, no money changes hands until March. So, from January to March, you're using the mark, but no paying clients until March. Under that scenario, the way that the case law has come down is that you're not actually using the mark in commerce until March, until you have paying customers. So, if you wanted to file an in-use in commerce application, you need to file it in March. What that means is you submit a specimen of the mark in association with the goods or services and how you're using it. The other way of filing is an intent to use application. So in my scenario, we have website.com. We're filing a trademark for website, and whenever we are not actually using it in commerce, if we don't have any paying clientele, or let's say we're not going to actually launch the site until June, and I know in January that I want to have that trademark, then we file an intent to use application. The intent to use application is exactly the same process as the in-use in commerce application. The only difference is after the examination period is over, at that time, after publication, you get what's called a notice of allowance. And then after the notice of allowance, you have 6 months to file your specimen. And there's an additional fee to the USPTO at the time of submitting your specimen. If for some reason you are not ready with your specimen, you can extend that time in 6-month increments up to 3 years. So again, in use in commerce application, you're using the mark at the time of filing and can produce a specimen at the time of filing. Intent to use, you are not using it, the mark at the time of filing, or do not have a specimen ready at the time of filing, and so you file as an intent to use and file your specimen later. Thank you.